So our topic this week for our Gilfix webinar, the critical documents that everyone needs at the age of 18 and why they're so important. We're also going to talk about what this means for a family as your child turns 18, some other critical issues that you need to revisit and think about when this happens. And as we jump in, I think I'd ask you, do you have adult children over 18 or about to turn 18? Are they going to college? Or are you 18, 19, 20 years old, just became an adult? Again, I don't feel like I was an adult till like my late 20s, maybe. But technically, legally, you are an adult. What do you need to know? This webinar is absolutely critical. So let's jump right in. Here's a key point. Everyone over the age of 18 needs these documents in place. And without them, you could be exposed to tens of thousands of dollars in court costs, but just as importantly, a lack of control and absolute messes can happen when we don't plan ahead. And again, just because you're young and in college does not mean you're not an adult, or that your child's not an adult, or your grandchild is not an adult. We have to live in the world of reality. So what are we here to discuss today? Okay. First off, what happens when my child turns 18, or when I turn 18, or when my grandchild turns 18? What are the key legal issues that we have to become aware of? And then what are the documents that are needed and why are they so important? How can I help my child with financial and business of life issues? How can I stay involved in medical decision making? What about getting access to educational records? There's a document for each of these. We're going to go through what those are. Do you have a child with a disability? There's some special considerations when your child with a disability turns 18. A lot of people think, oh, I have to get a conservatorship. We'll explain what that is. We'll also explain why maybe that's not necessary and how we've helped many families to avoid a conservatorship. They're very expensive and painful. Let's try to avoid them when we can. How to communicate with your child, or for kids to communicate with their parents about this. That's just a critical issue. It's a touchy subject, right? And then how to put the right plan and documents into place. And we have to point out this is for informational purposes. It's not legal advice. This is meant to be educational. For us to give you legal advice, we have to work with you directly as a client. So don't try this at home, but we hope it enlightens you and at least makes you aware of these issues. And if you want to take steps from this, contact us or talk to a lawyer, but it really should be us because we know what we're talking about here. But again, share this also if there's anybody in your world who can benefit from this. And I think you're going to find there's a lot of information here that we all need. So Mike, there was a recent article, and these come out every couple of years. There's a recent one in the Wall Street Journal, but we're not alone here. The documents you need when a child turns 18. I feel like every 6 months or a year, the New York Times, Wall Street Journal, the Mercury News, someone puts out an article about this. Mike, any thoughts about that?
Gratifying is big issue that we face on the ground. Just high net worth individual, it's everybody. So every time we see a red flag waved by the New York Times, Wall Street Journal, any major media, it's celebrate action. It's over. It just typically doesn't exist. So so hallelujah, we will. Of course, every few years you'll see this topic revisited in the media, often because there's a problem, some horror stories.
Yeah.
That's what today is all about.
Absolutely. If you have any questions, enter them in the Q&A function. We'll try to get some questions at the end. So let's start with the tale of losing control. Sarah and her daughter, Jen. So Sarah's daughter, Jen, turned 18. That's great. Jen went off to college. Jen didn't adjust well to college or adulthood. She had bad grades. She was missing class. She wasn't paying her bills. Jen ended up with some mental health issues and needed some help. And mom, Sarah, wanted to help her. But when she called the school about her daughter Jen's status, they refused to speak with her. She knew things were off. Her daughter wasn't reaching out to her. She knew where her daughter was. And no one would even tell her how her daughter was doing. Banks refused to release financial information. The school refused to release information about her bills for student debt. Doctors refused to speak with mom about Jen's medical issues. So mom couldn't help. She couldn't find out what was happening. I mean, what a nightmare, right? And this is not that uncommon. We have many clients whose kids go off to school and they face issues. We had a call last week, Dad, about a client's child who just had serious mental health issues, and they were frantically trying to find out where she was. But even if they sort of found her, would the institution or the place let the parents know? So it's all about how can we avoid this nightmare that Sarah faced when her daughter had problems.
And interesting, we are going to revisit this example later on. I just want to emphasize, we're not making this up. It was indeed last week when exactly the situation came up. The parents were frantic trying to find their daughter. When they did find her, they couldn't get information about how she was doing. They had to drive up here from Los Angeles. If they had information, simply had information and access, their lives and their daughter's life would have been dramatically better. So again,
Yeah.
very real service.
Yes. And I think your microphone is a little bit quieter. As always, we always have microphone issues. So to speak as close to the computer, I guess, as you can. We'll do our very best. Thank you for the note about that. But I can't hear you though, Mike. So it's there. And I also kind of have a loud voice. And I'm told I speak out pretty. My wife complains that I sometimes speak loudly at times, but it's good for this, right? So just really quickly, if you don't know our firm, we're Gilfix and the Pole Associates. I think most people here probably do, but we're very proud of our heritage. We're celebrating 40 years in the Bay Area, mainly based in Palo Alto, but we serve clients from San Diego to Wairika. If you're in California, we can work with you. We serve thousands and thousands of families. We've helped protect hundreds of millions of dollars in assets for our families. It's not just ultra high net worth people, by the way, middle class, upper middle class. If you have any assets, we can help you to protect them for multiple generations. And we want to take care of you, not just the parents, we want to take care of adult kids. And that's what this talk is all about. Our goal is to provide extraordinary value and peace of mind and multi-generational planning. We had a recent webinar on our Gilfix Law channel about the power of multi-generational planning. And I think this fits in with that. I was just on the radio on KABC in LA. Mike was just featured in the national media. NALA, the National Academy of Elder Law Attorneys, has a national paper that just a beautiful profile of Mike. He just published an article on Dynasty Trust and Bottom Line Personal. We are regularly in the media and we love to educate. And so thank you for joining us here today. And you're part of our community, and we thank you for that. What happens when my child turns 18? What are the legal issues? Or when I turn 18, right? Maybe you're 17 years old and you're wondering what happens, or you're just turned 18. What are the legal issues that come into play? What do we need to understand? It's a big deal when you turn 18, whether you're ready for it or not. So, Mike, why don't you lead us through what it means, legally speaking, when you turn 18?
Sure, and if you can't hear me well, please let us know. I'll do my best on our microphone system. Well, in the minds of many, age 30 is the new 18. It's a question of when is a kid maturing? When is the kid really able to handle being an adult? Because when they're 18, they're an adult. Now, many kids can handle that. Many are responsible. But let's face it, honey or not, still living their childhood, not responsible. Let's not get into who's at fault or why that's happening. It's a reality. That's the case. So because your child or you become an adult, parents no longer have access to information about you. Made this point, we're going to change it again and again. It might be educational records, finances. You may be in trouble financially. Your parents won't know unless the parents won't know unless there's some tool that will allow that to happen. Mm-hmm. So there's nothing automatic that lets financial institutions or college administrators or medical care providers, nothing automatic that lets them speak with the parent while that was the case when the child was 17 years of age. It shocks so many parents to learn this. But again, that's reality. That's the law in the state of California. You have to be practical here.
And I think a key point, and I apologize for the microphone issues. I think a key point here is that it's up to your child to give you, the parents, the ability to view records or be involved with finances. It's up to them. You can no longer say, I'm going to look at your bank records. I'm going to talk to your doctor. It is up to them to choose you or someone else as a backup in an emergency, to step in for them if they need it, whether it's a bank issue or a health issues. And I know when people are younger, a lot of people think, well, what am I going to need power of attorney or the right to see medical records when my kid is 18 or 19? But stuff happens. Accidents happen. Lots of kids study abroad. Not only can accidents happen abroad, but what if key documents need to be signed while your child is gone? What if they face financial issues? There are so many times where documents are needed, where bills need to be paid, or when there are medical issues. And Mike, this happened with us, with my sister Jamie when she was studying abroad.
In our family, a number of years ago, our younger daughter was in the jungles of Ecuador, and an insurance form came in the mail that needed her signature. Without signature, her insurance was going to terminate her. So we were able to use her power of attorney. We attached a copy, sent along, worked just fine.
Yep.
You know, there's no disability, there's no problem other than communication. It just made it impossible to communicate with her at that time.
Hmm.
So we appreciated tremendously the fact that we practice what we preach.
Yep.
When our kids all three turned 18, we had them sign powers of attorney and advance direct documents we're going to go through today. Stuff happens.
Yeah, and let's talk specifically about, and we get a lot of questions about this, UTMA, Uniform Transfer to Minor Act accounts, or joint accounts with mom or dad. And I can tell you in the last 3 months, I have personally dealt with 3 different client matters where grandparents or parents were frantically calling us saying, there's like over $100,000 in this UTMA account, Uniform Transfer and Minor account, that we didn't think about. And my kid's about to turn 18. I don't want them to get access to $100,000 the day they turn 18. So Mike, let's just talk about this and what they mean and why you may want to shift away from these right away.
So, you know, we all come up with practical solutions. Sometimes we have good advice, sometimes we don't. So with bank accounts, there's 2 or 3 alternatives, many of which you might have pursued. So one is this thing called UTMA, that's the Uniform Transfer to Minors Act account. You can put money into it, a grandparent, an aunt, an uncle, anybody can put money into that account that the parent typically manages. But when your child turns 18, maybe 21 if you check the right box or add that information, but typically at 18, they own that money. They control that money. If it's a couple $1,000s, big deal. You know, that may be just fine. But again, we've seen so many situations where the account, maybe it was a brokerage account, and some stock was put in.
And it grew, yeah.
So we've had to undo so many.
Yeah.
To undo means you need the cooperation of the child.
Yeah.
Usually, but there's no law. There's no guarantee that it's going to.
And what about these joint accounts, by the way? Because those can bring bigger issues sometimes.
Joint accounts are very practical. So you set up an account with your child. You know, let's say mom and the child do. Either one can write a check. Now, let's be really aware of the implication. If you have a joint account, if either person is sued, all the money in that account is exposed to litigation. So if it's a larger account and your child is in an accident, something happens and there is a lawsuit, be aware every penny in that account is exposed. The other point should be self-evident. The child can write a check on that account for the entire amount. Either one has complete unlimited control. So one of the messages here, if the account's relatively small and you're going to take that approach, it's not the only way. Of course, a child should have an account in his or her own name. You avoid the problem of exposure, but you do have that management issue. And there are ways to address that, which we will identify. And
luckily for you, Dad, I was totally ready to manage any amount of money when I turned 18. I was really on top of it. So it wasn't a problem. Although I don't think there was an account sitting there for me.
We're into this webinar here today.
That's not humor. That's the truth. I don't know. Actually, I don't really remember when I was 18. I probably wasn't very good at this. Okay. What happens when my child turns 18? Critical document that you need to create. Number 1, a durable power of attorney. Let's explain why it's so important, what it is, and how you put it into place. So, okay, you've helped. Let's paint a picture. You have a daughter. She's about to turn 18 or just turned 18. You've helped her your whole life with bill paying, with financial aid forms, with other business of life issues. Whenever she has bills, you help her out with it, right? Once she turns 18, you as a parent lose all access. The bank will no longer talk to you. The IRS won't talk to you. The student aid officials won't talk to you. Why? Because your daughter just turned 18 and she's an adult. She's no longer your dependent. How can this be rectified? Well, the durable power of attorney for finances. That's the answer. I was like this, like fist in the air, power of attorney. I'll point out why I think that's like the lamest superhero ever. Like, think about, I grew up with the whole He-Man. And you always say, by the power of Grayskull, I am He-Man. I think that's right. For those of you around my age, you might recognize that. I think, think of it like that. I have power of attorney. Lamest superhero ever. But it's important to remember it. Maybe you'll remember that term just because you'll think of the dorky lawyer putting his fist in the air saying, I have power of attorney. Yeah, I don't think many people really care about that. But anyway, it's really important to have. And what is it for, Mike? So let's jump ahead to what this is. So Mike, why don't you walk us through why it's so important?
Sure. So, power of attorney is just fundamental. Everybody age 18 and over should have one in place. You're basically putting in place a mechanism so that somebody can take care of things for you if there is a need to do so. Mm-hmm. So if you sign the document, the person that you name for the document is technically called the attorney in fact. It's not a great term. It's confusing. You think it's a lawyer. It's not. It's not. It's the person named in that document, depending on the language of the document, has the authority to sign your name, basically manage legal and financial affairs. Oh. If you can or if you don't want to, it can be very broad or it can be very limited. It can include the power to pay all of the bills, make sure taxes are taken care of. As I mentioned earlier, sign insurance form, apply for aid, on and on. There's two approaches that can be taken with the power of attorney. One is to sign it and make it effective immediately. And when an 18-year-old is signing power of attorney, we recommend that it's effective immediately. In other words, there does not have to be a showing of incapacity. You want it to work. It's fluid, without a problem. Yeah. If you make it the alternative, the springing power of attorney, that means that the document only goes into effect if there's a showing that you're not able to manage your affair. So you can see why, for an 18-year-old, that doesn't really make sense. If you're a lot older, it's may. Yeah. So again, the recommendation to keep it simple, make sure it's going to work as quickly and as efficiently as possible.
Yeah, as a side note, just about that, the springing versus this like right away, a lot of celebrity horror stories is when a celebrity gave their business manager or someone full power of attorney. They signed one of these and they made it active right away and they gave them too much power. And if you have a shady person you give power of attorney to, they can do a lot to screw things up because you are literally giving them legal authority to step into your shoes for financial and some legal affairs. So it's critical to understand what you're signing and why when you do it. For kids, as you said, Mike, not as big a deal to name parents right away.
Sure. So this actually makes the point that while we have presumptive language that we use in a power of attorney, some powers are excluded in certain circumstances. Yeah. In certain circumstances. So it's not a one size fits all. Yep. Make sure that the document is appropriate for the circumstance of the individual signing that document. Yes, exactly. And there another form sometimes in college. There's actually an educational release form, a specific form you can sign to get access to your child's grades. Power of attorney should cover that, but if their school offers that, you should fill that out as well. But the bottom line is everybody over the age of 18 needs a power of attorney. If you are watching this and if you are over 18, you need this document. If you have kids or grandkids who are over 18, they need powers of attorney. So I hope you got a lot out of that. Share it with someone who needs to know this. I think a lot of people are resistant to these, and you should do it the right way. You should work with an attorney to make sure you're not giving up too much power or giving away too many powers, because these can be abused if it's someone who is not trustworthy. So be very careful with this, but every parent should talk to their kids about this issue. Mark, let me add, it just occurs to me, I have seen one situation where a young woman turned 18 and she knew and she wanted to name her best friend, another 18-year-old. Yeah. Now, I could see why she thought of that, but let's just make it a general statement. Generally speaking, not a good idea. Yeah. Not a good idea. Naming somebody is giving them a tremendous amount of power, as Mark said, so we want to be careful as we prepare these documents. Yeah.
What happens when my child turns 18? Critical document number 2 for anybody over 18. If you are over 18, you need this too, an advanced healthcare directive. What is an advanced healthcare directive? Why is it so important? And how can we put it into place? So imagine a situation, we alluded to the mother-daughter situation where your child has just turned 18 and they're in college and they have a serious health issue. Maybe it's a mental health issue. Maybe they're in an accident. If they are over 18 and you find out they're in this accident, you call the hospital. The hospital technically will not give you any information about your child. And especially if it's not your child, if it's someone you love who's over 18 and you're not related to them, it's even harder. They won't even confirm if your loved one is in the hospital. Why? Because once you turn 18, you are an adult and you have the right to medical privacy. And unless you grant voluntarily the right for someone else to see your medical records and make decisions for you, they can't do it. If your kid's under 18, Mom and dad, of course, can make decisions with and for the child. But so for you or for me, if I can't communicate for myself in the hospital, who can? If I'm in an accident or if I'm in a coma or if I'm very sick, who do I trust to step in for me? And dad, you can't do it for me, right? I'm several years over 18 at this point. If I wanted you to step in for me, you literally couldn't do it unless I had the right document in place, an advanced healthcare directive, right? So
Right.
it's pretty insane that I think we just kind of we always are just thinking, well, if something happens to one of my loved ones, of course I can go to the hospital. Of course I can look at their medical records and the doctors will talk to me. But Mike, why don't you, I'll talk us through this. So basically, again, if you are watching this and if you are over 18, you need an advanced healthcare directive. Everyone in America needs an advanced healthcare directive because once you are 18, unless you explicitly give the power to people that you choose to view your medical records via HIPAA waiver and to make decisions for you, they cannot make decisions for you. Now, married spouse, sometimes there's ways for spouses to do it. But parents can't do it once you're 18. Friends can't do it. Uncles and aunts can't do it unless you name them in an advanced healthcare directive. That's what this document is for. It grants the trusted agent, the person you named, you should name at least 2 backups, we always recommend, the ability to view medical records via HIPAA waiver, to communicate with doctors, and even to make decisions about your healthcare. And if you have a child in college, it can give a parent the ability to speak with campus healthcare services regarding a child's healthcare issues. So if you don't have it, the doctors on campus will not talk to you. And it's also critical that if you're ever in a really rough situation, like you're in a long-term coma, what would you want? Would you want tube support, life support removed if you couldn't recover from it? Mike, you and my mom, Myra Gerson-Gilfix, were involved in the Drabeck case, one of the first right to die cases in California, a case I studied in law school. It's kind of cool to see a case that my parents worked on about that issue. But just any thoughts about the importance of an advanced healthcare directive and why we all need it?
Yeah, I think the point to emphasize here is there's kind of a myth that you need to do an advanced directive to deal with end of life circumstances, and that's it. And not the case. We are emphasizing here that it also deals with day-to-day medical care decisions that have to be made. You could be in the hospital and there could be an operation and you're not able to communicate and some decision has to be made. Well, you typically want a loved one to make that decision for you. So many circumstances, as if certainly including if your child is at college, as we have emphasized. So, think comprehensively, proactively about the role of the Advanced Healthcare Directive. It covers on many, many topics, way beyond, in addition to end-of-life circumstances.
Yeah, so if you are watching this, comment if this is like, whoa, I didn't know this. Leave a comment if you're watching on YouTube or recording. Share this with someone who needs to know they need to create an advanced healthcare directive. Typically, it should be created with an attorney. You can sometimes, like I go to Kaiser for better or worse. Sometimes it's great, sometimes not so great. But Kaiser has their own internal forms as well, like medical systems. Some hospitals do. No harm in doing both. If you're going to a specific hospital and they have their own internal forms, hey, no problem in filling that in, naming the people you trust. Those are usually pretty simple. They might not be accepted outside of that hospital, but also you should create an independent advanced healthcare directive form with an attorney. We help most of our clients with this, and that's one that can be accepted virtually anywhere rather than just a hospital specific form. But you need to do this. You need to talk to the people you might name in the document as medical decision maker, just to make sure that they're ready and willing to do it when the time comes. So recommend naming at least 2 people who you trust to step in. And again, if you're just turning 18, it's probably going to be your parents because they can't help you anymore once you're 18 unless you give them that power. So again, share this with someone who needs to see this. And let's move on. When you turn 18, there is another critical document that you need, even if you don't think you have much in the way of assets, and that's a simple will. So of course, if you have a lot of assets, you need a living trust, or not even a lot. If you have kids, or if you have any real estate, if you have over $100,000 in assets, you need a living trust. Otherwise, you're exposed to the courts. But if you're just turning 18, you don't have much in the bank, you at least need a simple will. Let's talk about why. And again, generally, a will is not enough. Watch many of our webinars on the Gilfix Law YouTube channel. Hopefully we make it very clear. A living trust is much better. A will, if you have any assets, any significant assets, if you just have a will, your assets are going to be stuck in probate for 2-3 years, ridiculous fees, totally public. But if you have a very small estate, you can avoid some of that. And it's a lot better than having nothing if you don't have much yet. But if your child just turned 18, or if you just turned 18, you're just getting started, you should create a simple will. Because if you don't, well, what happens? State laws determine where your assets go if you get hit by a bus or in an accident and die early. You have no say over where your assets go unless you direct them. And so again, a will is a lot better than nothing. Any thoughts there, Mike, about just we all need a will, right? At least.
But Tim says why a will is typically enough. In California, as an all-state, there's something called a small estate administration approach. So that an estate is under $60,000. You don't have to go to court through the probate process. It's an expedited, cost way of handling things. So smaller estate, or even no estate, because everybody has a potential estate.
Yeah.
A simple will is going to be just fine. So that's great for the kids.
Yeah, if it's small. Now, as we say here, if your assets grow, then you need a living trust. And if you're watching this, if you have a house, if you have more than about $100,000 in the bank, and if you care about what happens after you're gone and want to keep your family out of the court, a living trust is much, much better. And of course, we have many other webinars about just the structure of your trust, additions you can add, really powerful tools you can put in. But again, if you're just turning 18, 19, a lot of people don't want to think about their mortality. I get it. None of us thinks we're going to die ever until we get a lot older, usually. Although I've had my own brushes with mortality, as have you, Dad, and most of our clients have. But it's really important to at least have a will. And just for creating a will, by the way, you can create one properly. And if it's typed up, or if you work with a professional like us to create a simple will, we often do, you need to sign it with 2 disinterested witnesses. People who are not named in the document. And a weird rule, and I think this must have been for soldiers at war, but if you handwrite the whole will, you can just sign it. And if it can be proved that you actually wrote it, you don't need witnesses to sign that. It can be a valid will. So I think Aretha Franklin, she passed away recently. There's been all these fights in court. So one, she should have had a living trust. But I think, if I recall, they found a handwritten will in her couch or something. And it was more recently executed than some previous ones. And I think the handwritten will they found in the couch won out. So anyway, don't put yourself in Aretha Franklin's family shoes. It was years of fighting. Create a will at least, but as you build your estate, you really need a living trust. And we are getting some good questions. We'll circle back to those at the end. We just have a little bit more to go. And what happens if you don't? What happens if you don't put these 3 documents in place and you just turned 18? An durable power of attorney for finances, an advanced healthcare directive, a simple will. So let's go back to the story that we told of Jen and Sarah, where Sarah was the daughter, I think. Jen's daughter, Sarah, goes, and I hope I didn't reverse that, goes to college and has serious issues. She's having mental health issues. She's not paying her bills. If you don't have these documents in place, you cannot help your child once they are 18, or it's much, much harder. You can't get access to their records, right? And what if there's a conflict? What if all of a sudden there's a mental health issue, and because of that, your child all of a sudden temporarily hates you and won't speak to you? They haven't put these documents in place ahead of time. You might be barred. Unless you go to court and take a bunch of other very expensive, painful steps, you might be barred from even viewing their records. And what are the options? If you don't have these documents in place and your child needs help in medical decision-making and bill paying, what do you have to do? You have to go to court, and you have to get what we call a conservatorship. You have to prove to the court that, hey, my child is not able to manage their affairs. I want to step in and get court authority to take over their life. And that is a painful process. It can be humiliating for the person being conserved. And all their dirty laundry is aired. It's very expensive. We try to avoid conservatorships whenever we can, but sometimes that's what's required. So any thoughts there, Mike, before we move on to issues of disabilities?
Well, I think this is the issue of disability. So let's move on and we'll delve into this a little bit more deeply here in just a moment.
Yeah. So just to sum this up, really critical. You need to have the 3 documents in place. Otherwise, you can be stuck in court. And sometimes people complain like, I don't like paying a lawyer to set up documents now. You can pay a little bit now, or you're going to be paying a lot later if you don't have the right structures in place. Okay, what happens when my child turns 18? Well, you need to know if your child has a disability. This is a big issue. We work with hundreds of families with children with disabilities, with maybe it's mental health issues, maybe it's autism, maybe it's physical disabilities. And a lot of people come to us thinking, well, I was told that I need to get a conservatorship because my child is turning 18. It's not that simple. And I think we are unique in our field in that we really try to avoid conservatorships whenever possible. So, Mike, why don't you talk about our approach to this and how we think about this if you have a child with a disability when they turn 18?
I estimate that over the 40 years we've been in practice, for every 10 clients who come to us with this situation, a child with on the spectrum, on some other mental illness in particular, for every 10 who come to us, if we end up getting a conservatorship in 1 or 2, I'd be surprised. We can usually find a way around it. So what do we do? How do we go about it? A child may have significant disability, not able to manage school, not able to get a job, but still have basic understanding of who mom and dad are, and they trust mom and dad, and importantly, they're able to sign their name or something close to it. Yep. They have a California ID or maybe a driver's license. Okay, so that means presumptively that they could sign their own documents. If we can take this young woman who might otherwise need a conservatorship, and if she can basically understand the concept of a power of attorney, not go through the document page by page and paragraph by paragraph.
Nobody does. Well, we have still brilliant engineer clients who do, but even our lawyer clients don't usually read that. Yeah, we love them, but
my idea is awfully simple. If your child can basically understand a power of attorney and an advance directive, tone down, not elaborate. They can understand what those documents are and they can sign them. And typically we want to get them notarized. We've created an alternative structure so that mom and dad can do almost everything that could be done through a conservatorship. Now, the exception, of course, is if a child is a severe mental illness and we need to get what is called a 5150, where somebody is a danger to herself or others, schizophrenic, something, really, we can't avoid it.
Right.
Profoundly disabled, can't communicate at all, and we can't do it. The question is, again, why is a conservatorship needed? What decisions have to be made? So again, presumptively, we try to avoid it. It saves hassle and money. You can always get it later.
Exactly. Yeah, and the nice thing too, it's a way for your child to maintain autonomy rather than going to court to basically prove to the court that your child is incapable of caring for themselves and making decisions for themselves. And that's why, and you have to have doctors write up reports about why your child is incapable of doing this. That's a tough process, right? And that's taking away autonomy. It's literally declaring them in the public sphere, in courts, to be incapable of taking care of themselves. And just think about what that means psychologically for your child, if they can understand that at all. And what if and so again, as Mike said, there are some cases where we can't avoid a conservatorship. And we help many families with conservatorships. But what a wonderful thing if your child can understand enough to voluntarily give you and your spouse or someone in their family the ability to step in voluntarily. And again, you can always go back to court later if you need to. But once you get the conservatorship, it's a pain to end it. And sometimes, depending on what type of conservatorship you have, you might have ongoing reporting to the court. You might have to provide accountings to the court. That's expensive too. So not only is it thousands of dollars to set it up, not only is it invasive, not only does it undermine your child in a public sphere, it's a pain. It's a lot of work. Now, there's good reasons for that in some cases, but you can avoid it. Let's try to. Let's empower Americans with disabilities to take their own steps, to empower them to name people that they trust to step in without involving the courts. So that's one thing you taught me early on, Dad.
How responsible that is of your child.
Yeah.
Your child should become our client. Your child will be a lawyer. We would talk with them, make sure that they have a basic understanding. Again, detailed, sophisticated level of understanding, but do they understand that by signing this, we're letting mom and dad take care of things?
Yep.
That's really what kids are planning.
Yeah, and I would think, I don't know the statistics. I would bet that if every attorney thought about this the way that we think they should, there'd be 30, 40, 50% fewer conservatorships. I think too many lawyers go to this as the go-to first step, and we don't think that's the case. Again, not against conservatorships all the time, but if you're facing this, let's talk. Let's see if we can come up with alternatives. It's not always possible, but it's a wonderful thing when we can avoid that. Okay, what happens when my child turns 18? How do we put the key documents, power of attorney, advance directive, simple will, how do we put them into place? What's the best way to do that? Well, again, we talked about this before, durable power of attorney, advance directive will. beware of check the box forms. So there are plenty of places you can download simple versions of these. And a lot of the power of attorney documents that we see are literally check the box. And in some cases, that's okay. And often people just say, I check the box for all of the above. Do they really understand the powers they gave? And does that document include other steps that we might want to include? Do they include tax planning? If there's tricky tax issues, we don't generally recommend very simple forms. Here's another issue, by the way. A friend of mine just called me this week. His dad was in the hospital and could not communicate. His dad created a power of attorney. He did a downloaded form. It was notarized. He sends it to the bank. The bank looks at it. They say, that's great. We need an attorney note verifying that an attorney helped him to do this. They didn't work with an attorney. What was the alternative? The bank said, well, then we need your dad to sign a statement saying, I know what this is. They have a laundry list of things he had to attest to. But dad was incapacitated. That's why he needed the power of attorney in the first place. So he was literally stuck between a rock and a hard place simply because they didn't work with an attorney to create this document. So we always recommend working with an attorney, should be us or another expert in this area, to put these into place, because it's messed up. We don't pay Chase Bank or Bank of America to say this. We don't want them to require this. But they are so risk averse. They don't want to get sued. So they want 15 different ways to paper things to prove that they did everything right. So beware of those forms and make sure you understand what you're signing, because sometimes people give far more power than necessary. Again, there's so many celebrity stories of star athlete has a buddy who's a business manager. They sign a power of attorney, like, take care of everything for you. And then they wake up and a year later, millions are missing because that person abused it. So really important to create it the right way, and understand what you're signing, both from a medical and financial standpoint. And how do you do it, by the way, logistically? Work with our firm. If you are a client and you want to help your child to do it, they can work with us too, as long as you and the child are both okay and they understand that we can't take sides if you're ever in a fight. We often work with the adult children of our existing clients. And for any documents you create, the trust, the will, the power of attorney, advance directive, make sure you have at least two people named as backup. So if the first person named can't do it, someone else can step in. Mike, any thoughts about the best ways families can really get started in putting these into place?
Well, I think we're going to explore in the next slide the full part of how do you talk with your child about this?
Yeah.
I think not. And let me address that now.
Okay. So just, do you want to sum up this and then we can go to the next, how to talk about it?
Sure.
Yeah.
Let's emphasize we do discounts.
Yeah.
Planning. We only do a discount when we're doing a document for your child. One of us would meet and talk with your child to be sure.
Yeah.
By the way, the challenge to a 18-year-old science, as a practical matter, nobody's going to challenge. Let's face it. So we are careful. We got to make sure that there is understanding. We are very careful that the document doesn't give too much authority, that in a healthcare setting that we address only those issues with which your child is comfortable.
Yep.
Sometimes they don't want to talk about end of life.
So,
it's distant.
Yeah.
Keep the document in place. Having your child name somebody they trust. And how do you raise the question? Not easy all the time, but I'll tell you.
Okay. So, yeah. I agree. Let's actually, I want to make sure this is clear, because we do use these for shorter, separate videos at times. So when your child turns 18, we've talked about the 3 critical documents they need. How do you bring this up? How do you discuss it with your adult child and adult children? If you want to put these in place and coordinate with your parents, how can you talk to your parents about it? Let's just make this a quick discussion. So we'll make me the adult child and you can be the parent. It's a role we've played pretty much for the last 20 years, literally and figuratively. So Mike, thoughts about how parents can bring this up with their children as they turn 18?
I believe that the best approach is to make it matter of fact. Not like, oh, wow, I really need you to do this. You're going to give up all. Hey, what happens when you're in school? Let's make sure I can communicate on your behalf. 98% of kids are going to say, yeah, why not? Now, if there's a terrible parent-child relationship, obviously not. we're assuming a degree of good faith there. But if your child has a reasonably good relationship with you, they're going to get it. It does make sense. Okay. So the other point is that, and I would have you emphasize this to your children, that, I'm expecting you, right? I'm viewing you as an adult.
Yeah.
Acknowledging that we need you to sign this so that we can be a part of your life going forward in a very supportive way. So I respect you. I honor you as an adult, as an 18-year-old adult. Let's deal with it directly. And this is the thing. And by the way, I signed a power of attorney myself. I've done these things.
Yeah.
It makes sense. Anything can happen.
Yeah, I think that's exactly right. So again, we're talking about the power of attorney advance directive, simple will, that the documents that your child needs when they turn 18. And I like that. And I remember when I turned 18, you and mom had me sign a power of attorney advance directive. And the one thing I remember the most was like, we own the advance directive. You can say what you'd want if you're in an accident or out of it. And like the idea that I could say, "Ooh, I want drugs to make sure I'm not feeling pain." Now, for me at the time, I was like, "Oh, I can say that ahead of time." Like, yeah, I can authorize, painkillers if I'm out of it. I don't condone the use of painkillers, by the way, unless they're absolutely needed. But I was like, oh, that's kind of interesting. And you can also even authorize the music that you'd want. You can give wishes, at least, for the type of music you'd want played in your room, the type of entertainment you'd want played, because maybe you can kind of hear it if you're in a coma. So I think the idea of, you can also make it, I hate to say it, but like fun. You guys certainly sort of made it fun for me, the advance directive, to say, hey, look, if I'm out of it, I want to know that I'm not going to have horrible music played. I want to know that people I don't like aren't allowed in, but people I do like are allowed in. So there's all sorts of requests you can make. And Mike actually spoke on a panel for TV writers many, many years ago, giving ideas for this. And they used one of your ideas. So in a show, when someone was in a coma, they requested, Beethoven's symphonies to be played, and they played that in the room. So, and we've had clients request specific types of music. So I do think framing it, as you said, Mike, matter of fact, let's find the fun stuff in it. And so you can say, look, this is what the big time people do. Let's plan for success. You're going to be big time in the next few years. Let's make sure that you have legal and financial backing, and via power of attorney advance directive. And also, just as an adult, I think like a birthday itself can be a good time to bring it up. When you have an actual birthday, your life changes. Maybe that right before that you talk about it. But I think if you let it drift for too long, it can be a little trickier. But anytime something in the news comes up about power of attorney, or something in the media, a TV show talks about it, that's a good time to chat about it too, if you haven't brought it up beforehand. Any other thoughts, Mike, about communicating about this? We have another webinar, by the way, about how to communicate about estate planning and multi-generational webinars. So check our Gilfix Law YouTube channel. We have a lot of videos about how to communicate, and leave us a comment or a question if you have questions about how to best bring these issues up with your family. We'll try to get back to all of them. We'll get to some questions soon.
I guess my supplement comment is to really reinforce what I said about respecting your child when you.
Yeah.
Issue of are you mature at 18? When are you mature?
Yeah.
Yeah. Salute and reinforce the concept of maturity.
Yeah.
It can help to make your child more responsible, more aware of reality going forward. That's very amorphous, but I believe that is very, very important. Treat your child as an adult, respect your child as an adult, and have your child empower you. Not just you empowering your child, but your child empowering you. It works both ways.
Absolutely. So when your child turns 18, I want to summarize some of the key legal and estate planning steps that you really need to take. So I think the first thing we want to talk about, this goes both ways. Once your child is 18 or over, they're no longer a dependent for you. So it means you lose the ability to make financial decisions for them or manage their finances. You lose the ability to make medical decisions unless they empower you via durable power of attorney advance directive. You got to put that into place. But do your documents cover the fact that your child is now over 18? One example, if you have a power of attorney document, a lot of parents just assume, well, if I'm ever in an accident, I'm out of it, my money can still be used to pay for college for my son or for my daughter, or support that, pay for their medical bills. That is not the case. If you lose capacity and you have a simple check the box power of attorney document, the person who steps in to manage your life cannot use your assets to pay medical bills or educational bills for your child. If you want that to be allowed, your power of attorney has to address this. If you want to have the power to do sophisticated tax planning, now your kids are 18, your power of attorney needs to cover that. And you may want to think about naming your child now that they're 18, if they're very mature. I probably wasn't ready for that when I was 18. If they're very mature, maybe you want to name them as your backup decision maker, because once they're 18, they can be your backup trustee or your backup in your power of attorney document, your advance directive. And it's just a good time to revisit your plan. Your kid's 18. I think it's just a good point to take a fresh look at what your estate plan has. And of course, to have that conversation with your child about putting their documents into place. So let's start with you. It's kind of like on the airplane, right? Like if they say if we're losing oxygen, we're losing air pressure, and the safety masks come down, use yours first. You can't help anybody else if you're passing out. So make sure your plan is up to date, and then talk to your adult children about this. And just when it comes to these issues, Mike wrote a book, Beat Estate Tax Forever. It's available on Amazon and to our clients, that talks not just about sophisticated estate planning, but about all these basics. Any comments, Mike, on parts of the book you think are especially useful for people who want to explore this?
Well, one of the things I like most about the book, in addition to the fact that it's current, it's relevant, helpful, there's a chapter discussing the impact of inherited wealth, and importantly, the role that your kids might play in managing affairs for you and with you. So again, all these things fit together. As we reemphasize, multi-generational planning is where it's at. It works both ways, up and down in terms of authority and responsibility. It just makes sense. It's just logical.
Absolutely. Now, bringing it all together. When your child turns 18, what do you need to do? Well, it's a good moment in life to revisit your plan. So in addition to getting your kids to create their own documents, maybe you name your child as your backup. Again, your child then, once they turn 18, needs their own power of attorney, their own advance directive. And one thing we always want to remind our client community about, and just our general community, these are separate but direct but related. Are you protecting your children for what they're going to inherit and what they're going to have down the road? Two big issues that I think so many planners miss, and you, by watching this recording or live, are ahead of the game. Family protection trust. Do you want to leave assets for your kids? Are you leaving it directly to them? That's a mistake. Unless, I'd say for 90% of the families we work with, we recommend they leave assets not to their kids directly, but to family protection trust, generically known as dynasty trust. Protects them from divorce, can provide protection against lawsuits and future estate taxes. We have a webinar called What is a Dynasty Trust? There's a lot of views. Check that out on the Gilfix Law YouTube channel if you want to learn more about why that's so important. And if you want your house to stay in the family, we must be aware of Prop 19 in California. Without planning, property taxes could go up by 100%, 500%, 1,000% for your kids when they inherit your home, or if you have a rental property, unless we plan ahead. And we do at Gilfix and Nepal have sophisticated solutions. There are very few experts in California who understand this. Talk to us if you have questions about Prop 19. Again, we have a lot of webinars about that as well. But anytime there's a life event, I think that's a great excuse to bring the family together to talk about this, get your child to put their own documents into place. And again, a great time to revisit your own plan and make sure you're addressing multi-generational protection and against protection against massive property tax increases. So the very simple way, what do you do? Well, don't lose this opportunity. If you're watching this live or if you're watching this on our channel, while this is top of mind, you have a superpower. And that superpower is an awareness of these issues. And it's going to fade over time. You're going to forget. We get bombarded with stuff. But these are high leverage issues and high leverage decisions to make. And by that, I mean little steps can provide massive benefits down the road. And if you don't take steps right now, it can be massive costs down the road. So let's plan ahead. Meet with us if you're an existing client. Come back. Let's review your plan. If you have kids turning 18, hey, let's come on in and we can work with them directly with your permission, with their permission, to put that power of attorney, the advance directive, simple will into place. And we can always develop a step-by-step plan to make sure that your plan is updated as well. And we just want to make sure that you're all covered, that you are covered, but not just you, mom and dad, or grandma and grandpa, your kids, your grandkids, your parents are all covered. We love when we get to work across generations. Just this week, I've worked with 2 or 3 different families where there's parents and children both involved in meetings. And we love that. And we write articles about that and give talks about it. And if you have any thoughts or comments, leave them. Let us know if you have any questions or comments. And I just want to point out, it's not just Mike and I. We have an experienced attorney team. We have Nick Klingenberg, Renee Conrad, Francis LaPaul, our tax guru. They're wonderful attorneys. And we all work together as a team. So if you're working with me, you're also getting the experience of our other attorneys. If you work with Nick, you're also getting all of our experience and expertise. And between Mike and Francis, what is that, like 90 years of experience almost?
How about that?
Yeah. And if you add us all together, it's like almost 200 years of experience. I'm not sure, but it's a lot. And if you haven't already subscribed to our YouTube channel, you can always just point your camera at this. That'll get you to the thing. Literally point your cell phone at that QR code. Apparently that works. Or you can just search Gilfix Law on YouTube. If you're on Instagram, I'm launching an Instagram channel with 60-second tips. I just started it. It's just Mark Gilfix, my name, Markgilfix. So take a look at that. I'm starting to put some free content there. And again, our channel is growing, tens of thousands of views every time we check it. We have more subscribers. And by the time you watch this on YouTube, maybe it'll be even hundreds of thousands or millions. I don't know. But join our community. And if you want to reach out to us, like, comment, subscribe, share this with someone you think could benefit from it. We want to spread the word. Even if you don't work with us directly, we want to make sure that you at least understand the issues, because so many people are totally ignorant. And if you do want to meet with us, very straightforward to do it. You can contact us at gilfix.com. You can reach us at 650-493-8070. I think most importantly, you are ahead of the game. Spread the word. Let your friends who have kids who are turning 18 know about this. Send them this video if you think it's useful. Any other thoughts, Mike? We'll get to some questions in a second.
Let's make sure that everything's organized so that you don't have to waste money going to work. It's so fundamental. Again, intuitively, we know this. The point Mark made about while it's top of mind, hey, take a look at yourself.
Yep.
Human nature, if we don't act on it while we're thinking about it, it drifts as we are bombarded with the reality.
Bombarded.
So, take it to heart.
Yeah, excellent. We had some good questions, so we'll get to just a couple questions, then we'll wrap things up. So Daniel had a good question. If my child is severely disabled to the point of incapacity, how do these documents differ, or additional documents needed? So we pointed out that if you have a child who's turning 18, they have a disability, a lot of parents think, well, I immediately have to jump into a conservatorship, meaning going to court to get a court order giving me the right to take over my child's life, essentially. If your child doesn't have capacity, so the alternative that we love is, if your child is capable of it, you sign a power of attorney and an advanced healthcare directive. They don't need to understand the legal jargon. They just need to understand the basics of what those documents are for and who they're empowering. But if they can't do it, those aren't really options anymore. And you might have to go to conservatorship. I know there's a new movement to sort of put an in-between path for assisted decision-making. I am not yet expert at that. Mike, do you have any thoughts about that middle path?
Yes. So sculpture that you have this big piece of clay, you can carve out the powers that you want to retain for the individual if he or she has some level of capacity. And by the way, the comment that the child may be incapacitated, again, we explore what that means. That may or may not mean that the person can't think about signing a document. Let's assume not. Then we would look at the question of whether of what is needed. There's a conservatorship of the person, which is authority to make decisions about where your child lives, healthcare, and then there's the conservatorship of the estate. Your child may not have an estate, so that may not be needed. So even if we go to court to get a conservatorship, we want to keep it to a minimum.
Mm-hmm. Yeah, absolutely. So we'd have to kind of explore the situation in more detail. As we say, this talk is not legal advice. We have to really meet with you to provide legal advice and really understand all the specifics of your situation. Another question was, can a conserved child sign a will, or should their conservator sign it? What document is needed to bequeath assets of a conserved child after they die? Mike, why don't you take that? It's a very good question.
Yeah, 2 points. Again, even if somebody is conserved, they could retain the power to sign a will. Again, it's not all or nothing. So again, it's very circumstantial. Look at the individual, see what's appropriate and what isn't. And the other thing about assets, doing a will, that kind of thing. I mean, as a parent, you would not be leaving money directly to that child. You'd be creating a special needs trust to hold assets for that child. And you would decide in the contents of the special needs trust what happens with money remaining in that trust upon your passage. So you, the parent, you're going to put the inheritance plan in place for what happens in the distant future when your child passes away. So we don't want money to go into that child's name unless there's no alternative.
Yeah. That's a great point. We have a lot of webinars on our Gilfix Law channel about special needs planning. Mike and I co-authored a book called The Special Needs Creation and Management Guide, available on Amazon and to our clients. And we have a number of webinars on the Gilfix Law YouTube channel about special needs planning, where we really go into much more depth about that. So let's wrap this up. I think, thank you so much for joining us here today. If you think this video could be useful to anybody else in your life, share it with them, spread the word, like the video if you can, comment, leave us notes. We'll try to go back and circle back to YouTube and answer questions if we can. Reach out to us at gilfix.com if you'd like to meet with us, but subscribe to our channel if you haven't. Spread the word. Thank you so much for watching. I hope everybody is doing well, staying safe, sane, and healthy. And we're going to wrap this up now. So take care, and we'll see you soon.